All right, it's showtime. Hi, folks. Question. How many of you have ever thought to yourself that if anything were to happen to me or my spouse, either our kids or our siblings are responsible adults? They will sort things out in a fair way. Or we really don't own that much. I don't think that we need to put together a whole estate plan. That's more for rich people who have millions and millions of dollars, not us. Or have you thought to yourself, when I think about this topic, us passing away, it really gives me anxiety or makes me really sad. So I just don't think I want to think about it. If you have had any of these thoughts, you're not alone. In fact, I'd say that you're probably part of the majority when it comes to this topic. With that said, I must commend you on taking this first step and joining us today to discuss this really important topic today. As you know, our topic is understanding, or let's call it demystifying, estate planning. And I'm your host, Brian Dougherty from PLC Financial Solutions, located in Fort Washington, PA, along with my beautiful, wonderful partner in business and life, Rachel Dougherty. Say hi, Rachel.
Hey, everybody.
Rachel's going to be our moderator for tonight, as always. She'll be handling the chat and Q&A boxes at the bottom of your screen. But before we get started, let's take care of some general housekeeping first. If the screen is not big enough for you to read, you can click on the View Options drop-down at the top right of your screen to make it larger. All you got to do is move your cursor around or click on it a little, and you'll see it pop up. And once you click on it, it'll turn into a little drop-down, and one of the choices is say to get larger. Also, you'll see that there are two boxes at the bottom of your screen. One called Chat, it's for your comments, and the other called Q&A for your questions. Please use them accordingly, and Rachel will respond to them in kind. Next, I'm sure that many of you will have questions about the material as we go along. However, since we have only a good bit to cover and only an hour to cover it, I'm going to ask you to put your comments and questions in those boxes below. Or you can even email them to us at info@plcfs.com. That's info@plcfs.com, if that's easier for you instead. Because at the end, we will be staying for some extra time to cover as many of them as possible. However, if we don't cover yours, we'd be happy to answer it either by email or even a 15-minute Q&A phone call scheduled for another time. Rachel will be posting a link for you to schedule that at the end if you so choose to. Next thing, this webinar is being recorded and it will be sent to everyone who is attending tonight. So don't worry about missing anything. You'll have plenty of time to check it out again at your convenience. Also, because we want to make sure that you're all paying attention, and because we'd like you to have some fun as well, before we answer any questions, we have a 6-question quiz for you at the end. And the first person to answer each question correctly inside the comment box will win a $10 gift card to a store of your choice for each question that you get right. So make sure you have your handy dandy notebook next to it so you can jot down some brief notes related to some special bullet points that I will be pointing out as we go along. Finally, it's my obligation as a financial advisor and a fiduciary to inform you of our RIA's disclaimer statement, which is that our investment advisory services are offered through Fusion Capital Management, an SEC-registered investment advisor, and we only transact business in states where we are properly registered or are excluded or exempted from registration requirements. Also, SEC registration is not an endorsement of our firm by the Commission and does not mean that our advisors have attained a specific level of skill or ability. And most importantly, all investment strategies have the potential for profit or loss. So now that we got that over with, I have one for you as usual. Why are ghosts such bad liars? Because they're easy to see through. And I got that one myself. And guess what? I used it the last time we did this webinar, and I loved it again so much, I did it again. All right, I'll keep the day job as always. Okay, let's get started. Hold on, my other computer's messing with me. All right, so welcome to our Understanding Estate Planning webinar. It's our third time presenting this topic since last year. But since it's it's our fourth time. Since it's such an important topic, we decided to add it to our annual rotation of workshops. That being said, we have so much to share with you today. We'll be providing answers to the most commonly asked questions on the topic and providing valuable information and perspectives in regard to the more basic aspects of estate planning. Things like, what is the difference between a will and a trust? What's included in each? What does a power of attorney do in regard to my estate? And will I need to appoint guardians in my situation? What is the best way to structure my beneficiaries? I think you get the point. This is a lot of important stuff, folks, and we all really need to figure it out before it's too late. So, on that note, let's do it. So, what is estate planning anyway? Well, estate planning is the process of reviewing your assets and belongings to determine how they're going to be preserved, managed, and distributed. Assets include things like real estate, cars, stocks, artwork, life insurance, pensions, and yes, even debt. Proper planning also considers the management of your financial obligations in the event that you become incapacitated. For these reasons, estate planning is an essential component to your overall financial plan. It allows you to gain more control over various aspects of your life, both during your lifetime and after it. Now, I'm going to say this a few times tonight to stress the point. Please seek out the assistance of an experienced attorney in estate law or an experienced estate planning mentor to do this. It's absolutely essential to have your financial wishes fulfilled. Now, first and foremost, let's talk a little bit about why so many folks seem to avoid putting a sound estate plan together for themselves and their families. Now, cognitive dissonance seems to be the number one reason. So what is that? What is cognitive dissonance? Definition of it is, it's the state of having inconsistent thoughts, beliefs, or attitudes, especially as they relate to behavioral decisions and attitude changes. It occurs when a person holds contradictory beliefs, ideas, or values, and is typically experienced as psychological stress when they participate in an action that goes against one or more of their beliefs, ideas, or values. In other words, it stresses people out. Basically, it's a long way to say that. Also, here are some interesting statistics that you may relate to. 47% of people say they need a will or trust, but they haven't gotten around to it. However, a survey by Merrill Lynch asked, how would you characterize someone who died without their affairs in order? Interestingly, 88% of the people chose words like irresponsible, inconsiderate, and ignorant to describe people who check out from this life without their affairs in order. Now let's take a look at what may be causing these contradictory beliefs. Most people Imagine that they have plenty of time to get their affairs in order. And most of the time, this is what leads to a lack of urgency. Unfortunately, putting off estate planning places you and your family at a significant disadvantage in the event the unthinkable happens. In addition to this lack of urgency, many people feel intimidated by confusing jargon and the potential expense associated with estate planning. Some also fear the process will be emotionally demanding and time consuming. And let's face it, some people just don't want to think about themselves dying, which just causes us to just keep putting it off. All right, let's say that we have gotten over our cognitive dissonance, plain old stress. We feel related to this stuff. What are the main steps we need to take when it comes to creating our new estate plan? When creating your estate plan, there are 6 major decisions you will need to address. Bulletproof one, bullet point one, bulletproof. Bullet point one, get them notebooks out. Bullet point one. The first is, who will get your assets when you pass? Whether you wish to leave your assets to your children or gift them to your favorite charity or other loved ones, you will need to dictate this by naming beneficiaries. So remember that, bulletproof one. Who's going to get your assets when you pass? You're going to need to name beneficiaries. First thing. Designating heirs for your assets is in the main component of estate planning. Individuals and families who do not have an estate plan are at the mercy of the court when it comes to deciding who gets what. This can sometimes take a while, and in some cases can be costly and even get ugly with some families if not planned properly, which is, of course, why I recommend a sound estate plan in advance. Bulletproof. Bullet point two. I keep saying bulletproof. Bullet point two. Bullet point two. We're really going to hit you with these bullet points right away, folks. The second decision you'll need to make is the method or time frame related to the distribution made from your estate. This involves determining how your beneficiaries will receive your assets if you were to pass. Now, depending on the age and financial capabilities of your beneficiaries, you may wish to delay distributions. You may also wish to delay distributions in order to reduce the inheritance tax burden of your beneficiaries, which is in PA currently 4.5% to direct heirs/children, 12% for siblings, and 15% for all other beneficiaries outside those lineages. Also, you may even want to stipulate that younger beneficiaries under 18 receive their portion in stages rather than in one lump sum. And for that reason, that some people designate, for that exact reason, that's why some people designate a specific portion of their assets to be distributed at a certain age or even at various ages as they mature. There are numerous reasons why people may want to delay distribution. Some can even have to do with stipulations related to alcohol or even drug abuse. As you can imagine, how habits like that can affect the decision-making ability of a beneficiary. Bullet point three. Bullet point three. I told you we're going to hit these with you quick, fast and quick. The third decision that you need to make when deciding as it relates to your estate plan will be who your financial power of attorney or POA will be in the event that you can't make them your own decisions for yourself at some point. The person or persons you name should be someone who is responsible, especially financially, and is capable of handling finances for you and is generally a good decision maker. Most people have a family member, either one of their children or a sibling, assume this role. However, it can be a friend as well. Generally, I recommend naming 2 or 3 potential POAs, power of attorneys, if possible, in order of preference, just in case your first or second choices might predecease you. Bullet point 4. The 4th decision is deciding who the person or persons will be as your healthcare power of attorney. He or she can be the same person or a different person from your financial power of attorney. This is the person who will make healthcare decisions for you in the event you cannot make them yourself. Again, you should definitely appoint someone who can make decisions during difficult and emotional times, but maybe even someone who has a better understanding of those, better understanding than most when it comes to healthcare issues. I've had clients who have children or siblings that are doctors or nurses who they feel more comfortable making these types of decisions for them. But they choose a different child or sibling, sometimes even a non-relative, to be their financial power of attorney because they felt that they would be better with money issues. These are all good considerations when choosing between a healthcare power of attorney and a financial power of attorney. Another thing to note here is that the document used for this it also allows for you to state your end of life and organ donation wishes as well. Again, it is usually recommended that folks name 2 or 3 potential healthcare power of attorneys in order of preference, just in case 1 or 2 of them predeceases them. Bullet point 5. Did I sneak it good enough, Rach? Bullet point 5. The 5th decision when creating an estate plan is deciding who will be your successor trustee if a trust is involved, or who will be your executor if it is just a will in place, to make decisions for your estate once you have passed. So, bullet point 5, who's going to be your either successor trustee or your executor? This is important because after a person passes, their power of attorneys will no longer be in force, and in order for your wishes to be carried out, they will need to appoint either what is known as a successor trustee to take their place as the trustee of their estate if they have a trust in some sort in place. Oh, also, just a side note when it relates to that, the most common trusts that are used for families are called revocable living trusts. Or if there is a trust, if there's not a trust involved with the estate, then they will need to appoint an executor to carry out the wishes that are in their will, which is also known as the last will and testament. So, bulletproof 5, you have to appoint, make a decision about who's going to be either your successor trustee with a trust or your executor if it's just a will. Now, I must also mention that the successor trustee and the executor do not have to actually be the same person, but most of the time they are. Plus, the major differences between the two is that a successor trustee carries out the wishes that are in a trust, and the executor of a will carries out the instructions that are in a will. This is an important distinction because there are sometimes things like retirement accounts, sometimes bank accounts, and even life insurance or jewelry that cannot be titled or put into a trust and need to be distributed directly from a will instead. Again, of course, the person or persons that you name should be people who are known to be responsible, especially financially, and are capable of handling finances for you and have a history of being good decision makers when it comes to these things. Another thing to note is that it is not uncommon in some situations where people who do not have anyone in their lives like this to name a professional trustee or an executor rather than a family member or friends. In fact, there are actually paid services that you can be used for this purpose. Obviously, it's not preferable, but sometimes necessary. Again, finally, I generally recommend that clients name 2 or 3 successor trustees or executors in order of preference, just in case 1 or 2 of them were to predecease them. The 6th and final decision to be determined. I did not do a bullet point on this. There's no bullet point on this one. The 6th and final decision will be to determine who will have legal custody of any minor children should you pass away, if there are minor children involved. Your appointed guardian will work with the successor trustee to access funds for the care of your children. Of course, the best person for this job is someone who will care for your children in a similar manner as yourself. Think about the values you wish to impart and the level of care your children will need. Many people name parents, siblings, or close friends as their appointed guardians. Again, naming multiple successor guardians in order of preference is recommended here as well. Okay, so now let's talk about what a trust is. A trust is a vehicle that can be created and used by any person or people for the purpose of distributing and transferring their assets to their heirs when they are not able to do so themselves. Also, there are many types of trusts to choose from, depending on the function you wish to carry out. There are trusts, there are special needs trusts, revocable trust, irrevocable trust, asset protection trust, charitable trust, constructive trust, spendthrift trust, tax bypass trust, and even way more than that. I am not an attorney, so I don't have a specialty in understanding all those trusts, but I know they exist. Okay. And like a will, a living trust will give directions to your successor trustees. Again, this is the title of the people that you choose to oversee your trust after you can no longer do it. On who your property should be transferred to after your death. It is also known as a living trust because it is created while the property owner, also known as the trustee or trustor, is still alive. As the trustee or trustor, you can make changes to the trust at any time while you're still alive. And you have full access to all the property that is titled or funded into it as if the trust did not even exist. However, unlike a will, a living trust passes property outside of probate court. This is a big distinction, which means your assets can be passed directly to your named beneficiaries without a court involved and holding up the process. With that said, the costs of probate usually differ a great deal depending on the city or bureau that you reside in. You should do a quick Google search to see how much potentially your estate size. They charge by the value in dollars of the estate usually. How much it is to see if it makes sense for you to have a trust based on that, based on what the value is and what they charge. Now, there are some noted similarities between a will-based plan and a trust-based plan. First, both a will and a trust allow you to control who gets your assets at your death. How those people or entities get your assets, and who is in charge of making financial decisions at your death. Second, both wills and revocable trusts can be changed provided you have the mental capacity to do so. Also, both documents are set in stone upon your incapacity or your death, meaning no changes can be made once you are either declared incapacitated or you have passed. Now, let's discuss the differences between wills and trusts. When it comes to wills versus trusts, there are actually more differences than similarities. First, a trust will, like I just mentioned, avoid probate if it is funded properly. Unlike a will, which is created in order to tell a probate court where your assets should go. On that note, in some states and situations, probate can be more costly than other, more time intensive and open to public record. So, in some states, not all, the probate can actually be cost a lot versus other ones. And it can be more time intensive, and the whole thing can be open to public record, meaning anyone can show up to find out what's going on and to find out who is getting what. Again, if done properly, trusts are far easier to administer and are completely private in nature, while wills become public record and can take years, in some cases, to distribute, especially if they're contested in any way. Finally, a trust is considered more comprehensive as well because it allows you to control both what happens now while you're still alive, if you become incapacitated, and what happens at your death. While a will, on the other hand, only controls what happens at your death. Now, when you have a trust-based estate plan, you also have a will that goes along with it. And that's important because if you did not put all of your assets into your trust, especially those that are purchased after the estate plan is put into existence, the will would then govern at your death where all your assets would go. The beneficiary of your will is your trust. This is what is referred to as a pour-over will, because it pours all your assets into your trust at your death. So in most cases, people who establish trusts for their estates end up purchasing many things that can't be titled in their names after they create the trust. All these things will automatically become part of their estates as a result of their pour-over will. For example, if jewelry or artwork was purchased afterwards and you didn't have the chance to add it specifically to your estate plan, then it would still be included. It would still be included in it as a result of the normal language used in most pour-over wills. However, it would most likely be sold and the value attained would be split among your beneficiaries equally, unless you specifically name it to go to a certain beneficiary or beneficiaries. Additionally, one major thing to note is that in a number of states, the will is usually the primary place where you can name guardians for minor children. Okay. If you have named beneficiaries on assets, things like life insurance or retirement accounts, for example, the beneficiary designation controls and supersedes your will. This is why it's always important to make sure your beneficiary designations are in line with your estate plan. In fact, in some instances, people will even make their estate the beneficiary of their retirement accounts or their life insurance. That may or may not be a good idea depending on the circumstance. If you want to control the flow of those assets going to your beneficiaries for some reason, then it may be a good idea. I could also, when it comes to retirement plans, there are different rules as it relates to beneficiaries when it comes to inherited IRAs, but it could dictate how it's going to be distributed for required minimum distributions, and that could be an advantage or a disadvantage depending on how you see it. You definitely have to consult with a tax professional in that. However, there are some instances where it makes more sense to designate your trust as your qualified retirement plan or IRA beneficiary, specifically if you would like to better control the distributions of the account, or you would like to shield the assets from creditors or anyone that would consider these assets as part of your heirs estate after you're gone. Normally, once it becomes part of your heirs estate, creditors can go after it when they couldn't if it was in the trust. This could be the case for a handicapped child as well, that they may lose certain benefits if the assets were to be considered part of their estate. So, which is right for you? In most cases, if you're trying to space out distributions for your beneficiaries, such as minor children, avoid probate, and want to exercise more control, you should consider a trust-based estate plan. However, if all your assets are going to pass through your heirs via beneficiary designation through either life insurance and or retirement accounts like IRAs or 401ks, and there is no reason to hold things back from your adult beneficiaries, a will-based estate plan may be all that you need. But if your situation is more complicated than that, then you probably should consider creating a trust-based estate plan. Just like many people review their financial plans on an annual basis, it's recommended that you review the circumstances surrounding your estate plan on a regular basis as well, or at least when life events occur, such as births of children, deaths, and changes to marital status, changes in marital status, or when anything happens that may affect your final wishes. However, some noted times that you should consider making changes to your will or trust include changes to health or wealth, relationship change to your power of attorney, successor trustees, or a guardian, real estate changes, if you get a new house, tax law changes, because it's not uncommon for old trusts to sometimes have language in them that are based on old tax laws, which can sometimes increase taxes on beneficiaries. So, how important is estate planning? Well, folks, estate planning is really all about protecting your loved ones in the worst case scenario. Bullet point 6. Really snuck up on them that time, didn't I, Rach? Get them notebooks out. Bullet point 6. This is a little bit complicated, this one. So I'm going to go slow with this. The primary benefits to estate planning include things like these. 1, the ability to choose who will inherit what your possessions and valuables are, who will inherit what among your possessions and valuables you would want them to have, and the terms in which they can be transferred. So let's just put it like this. 1, who will inherit your possessions and valuables, and how they'll get it. 2, it affords you the chance to name your children's guardians in the event of an unexpected death. So it allows you to choose the guardian as number 2. Number 3, it can in some cases help reduce taxes on what you leave behind. In some cases it can. So reduce taxes. Number 4, and because it minimizes the chances of family strife or problems, it can also help prevent ugly legal battles that unfortunately sometimes occur when these details are left for others to deal with. So it can minimize family problems. Number 4, minimize family problems. That bullet point 6, there's a lot to that, right? We're going to see when this quiz comes up, Rach. Gonna have to have some sharp ones on this. Also, a good estate plan plans for as many contingencies as possible. Remember, they say in life you should always have a backup plan. The same is true after you die. This is why I recommend naming several backup successor trustees in your plan, or executors, or power of attorneys. Estate planning is the only way to ensure that your final wishes are carried out, especially when it comes to your assets and your family. The goal, of course, is to leave nothing to fate. Folks, grieving over a loved one is stressful enough. Having a plan in place allows your family to focus on what matters during those difficult times, rather than them trying to decipher what your wishes may have been. More often than not, families who do not have a will or trust fall into disarray, sometimes even going into a battle over what they think they deserve from. Believe me, this type of strife can damage these relationships permanently in some cases, and it can easily be avoided by creating an estate plan before it's too late. So I strongly encourage you to do so as soon as you can. If you want your assets and your loved ones to be protected following your death, you're going to need an estate plan. Without one, your family could not only be left dealing with a lot of extra stress and personal challenges like those we just mentioned, but they could also be faced with significant tax burdens as well, especially with inheritance tax. That's a big one. And to top that all off, without a directive from you, the courts would end up designating how your assets are divided, and who gets to raise your children, if that applies to your situation. So as you ponder this very important topic, please keep all these things top of mind. All right, the following have been referred to. So Rachel's going to put our resources up there. Folks, that concludes the learning part of our workshop for today. And I hope you were paying attention, because this is when things are going to get really fun. Let's get started with our 6-question questionnaire, 6-question quiz. All right. We ready for this, Rach? Okay. Question number 1. What is the first decision that needs to be made when creating an estate plan? The first decision. In the chat box or Q&A box, we got. Yes. Who gets assets? And got that first. Frank said beneficiary. I don't know. Ed's right. Frank's right. I think we might.
Both of them.
I think we're gonna have to call that a tie. Right, they're both right. They both hit at the same time, right about identical time. So we're gonna go a tie on that one, guys. All right, so please put in the box where you would like your $10 gift card from. Second question that needs to be made with an estate plan. Our second decision. What is that? Oh, all right, Ann, I see it. What is the second decision that needs to be made in estate plan? Second decision, what is it? Assets to be distributed? No, not exactly. Now the beneficiaries were the first one, Patsy. It's more about how they're going to be distributed, right? And what did we refer to that as? I'll give you a hint. Some people.
Oh, here we go. Amphi. Got it. It says time frame.
Yes, the
Where the
time
distribution
frame. That's right, Ann. Exactly. All right. Third question. Again, what is the third decision that you need to make when creating an estate plan? The third decision.
Oh.
Come on.
No, it's moving slow.
Remember, it had to do what?
Yeah, I think Frank got a power of attorney.
Yep, power of attorney. All right. Frank, let us know where you want that gift card from. To. All right. Fourth question kind of coincides. What is the fourth decision you need to make when creating an estate plan? The first one was really technically the financial power of attorney.
Mm-hmm.
What is this one? Very closely related to it. Healthcare power of attorney.
There we go.
It
Yeah, it's something you definitely want to make sure you have both if you do have a power of attorney, because a lot of people don't realize that they're going to need both.
Yes, exactly.
I've run into that on more than one occasion.
Absolutely. I say we give this to Patsy, guys. They all kind of hit at the same time. I hope you're okay with that, Ann and Frank. All right. Fifth decision. Our fifth question. What is the fifth decision you make? And this is the last one. There actually are 6, but I only put the first 5 in there. So we covered the power of attorneys, but did we not? What did we not cover? And remember, the power of attorneys are for when you're alive. The other ones, who will be the successor trustee or executor? That's right, Ann. Good. Wow. All right. I was worried about them ones, right?
Well, it was a lot of info packed into one.
Yes, it was.
There.
It was. Okay. Last question. We're off the steps related to the what the decisions you need to make for a estate plan. So, name one of the 4 primary benefits to creating an estate plan. 1.
And Frank said, who will inherit?
Let's see. Yeah,
Part of it.
that's definitely part of it. And Patsy got reducing taxes. I think we got to go with Frank on that, Patsy. Yeah, I think that's part of number 1. The ability to choose who will inherit your possessions. Yeah, good job, guys. Good job. This was a tough one this time, right, Rach?
Yeah, well, it was a lot of information that was closely related, so it was hard to, but everybody good.
Yes, absolutely. Okay, now we have just enough time to answer a few questions. Any questions there, Rach, in the chat or the Q&A chat of these, or any in the email?
All right, so it looks like we have, let's see, how much does it cost to put an estate plan in place?
That is a good question. Very, very good question. Well, it can vary. That's a great, that's for sure. And it depends on who you have do it. You know, there's a dilemma, I think, in PA with a lot of attorneys when it comes to creating estate plans. I've talked to many of them, and when people approach them about estate plans, a lot of times they give them advice like, oh, well, you know, you're better off just doing a will, which will go through probate, because in PA or in, you know, city of Philadelphia or what have you, in most of the bureaus, the estate, probate court fees are fairly reasonable and are pretty timely. And the issue that I find, and they say, because if you pay me, I've never found one that will do it for less than $3,000. I had a client pay $7,000 one time. So I always tell people, you know, it's going to be probably somewhere between $3,000 and $7,000 if you have an attorney to do it. But if you do look up your, and I have looked up the estate or the probate fees, and how they work it is by the value of the estate, including the home value and everything. And as it goes up in increments of usually $100,000 to $200,000, and then the fee cost, the probate fee is higher and higher. Usually they can get up for middle to upper middle class people. I think somewhere around maybe somewhere between $1,000 and $1,500. They have a lot of little incidental fees besides the probate fee for processing and all this stuff. And so I always say, now, I personally, I'm an estate planning mentor. I can't give advice related to estate planning law or anything like that, but I can help guide people through the process. I know the process well. I work with an online legal service, and I'm able to, through attorneys through that service, able to provide it for less than a couple $1,000s, which means that you could provide the convenience for folks if you so wanted to. 98% of the people, I'd say, fit under normal guidelines where there aren't special type trusts that are needed and things like that, are unusually special trusts. In that case, with the system I use, it gets flagged and then the attorney has to be pulled into it. But yeah, and so for maybe a little bit more than it would cost them to go to probate. And believe me, I've been to probate court for my mother and whatnot. You have to maybe go down a few times. It's take off from work. It's especially if you're, usually you don't get hit with it for about 9 months, something like that. But it can be, a little bit alarming that you got to find out that sometimes you got to pay an inheritance taxes on things like a car that, my mother owned. She had a loan on the car, but I still have to pay inheritance tax on it. So you could save all that frustration for in and around, maybe a little bit more than what it costs to go down the probate. And you can have it all be done, quick and easy through an estate plan. So I tell people with your without an assistant or with assistance, like mentor assistants, around 2,000 or so, a little less maybe. If there's a trust involved, and if it's an attorney, anywhere between 3,000 and 7,000. A lot long-winded, but man, I've had a lot of crazy experiences with that, and was really the reason why I got into it, because several of my clients really needed some planning for it, but it had a bad taste in my mouth with the one attorney who charged the client $7,000.
Mm-hmm.
So, all right, any other questions there?
Okay. How can an estate plan save me or my heirs in taxes?
So yeah, I'm not a tax professional. Okay, I have read of all kinds of convoluted ways of creating different trusts to do things to really be able to reduce taxes, and you need a tax attorney probably for that. But just one of the things that I know is kind of more of a normal thing is, many times your people, most average people have either IRAs or 401ks or some type of taxable account at a brokerage or something like that. And so their heirs are going to incur taxes on them when they take them over. If it goes into a trust, you can actually distribute it a little over time, especially on taxable accounts. Other assets like a home or whatever, if you sell the asset, you sell a home and hold those assets in a trust. You could portion that out over time, and they're only going to pay that 4.5% or 12%, if it's siblings, or for that matter, if they're just heirs, not unrelated to you, 15%. They're only going to pay that on the portion they got portioned out every year. So could help them reduce their taxes on an annual basis if you do it over time. That's one of the more simpler ways that I know. But there are lots of convoluted ways to use different kinds of trusts that can make your head spin, that I know can be done even, more drastically, but a lot less common and usually for people with lots of money. Anything else?
Okay, so let's see. Is probate really that bad in PA?
Well, again, a lot of attorneys that you talk to will say it's not that bad. And I think it's because, they just don't want to charge people. They don't want it coming back on them that they charge them, way more than it would have cost them if they went to probate. PA is one of your easier probate related states. Your timing wise, how quickly people can go through it. Although, it is an inconvenience, and there will be probate fees on whatever goes through. Like, I know, just shocking, my mom had that car that was only worth about $5,000. I got hit for a $300 fee for it. I'm like, okay, and plus there's a loan on the car. So I now had to pay the car off, but I had to pay the fee. I had no idea. And so then I gave the car to Annie, remember, my sister. So my head was spinning a little. I couldn't believe I was paying money for something that I didn't I had no idea. So yeah, I mean, is it that bad? It could be a lot worse in other states, but I think it can surprise people, and it will tie up their time. That's for sure.
Mhm.
Anything else?
Okay, it says, if I don't have any children, would an estate plan be necessary for me?
Well, believe it or not, the people that I think are less likely to need estate plans with the trust. Everybody needs an estate plan in terms of a will and whatnot, and power of attorneys and that. Everybody needs that, in my opinion. But the ones that maybe don't need a trust are the ones where it's real cut and dry. Like maybe they don't have any assets that would go into a trust. And maybe they don't own a home. Maybe they rent. But maybe they have an IRA, and maybe it's sizable enough, but they have all their children, I think, are all fairly responsible. They're of age, and they're just they're just gonna. It's all written in the beneficiaries. They're all written in as the beneficiaries of that account. Boom, cut and dry. It's not going to go to probate. They don't have anything to go through probate, and they're going to go anything of really substantial value. And car might go through them. A car will go through. But otherwise they could maybe get away without a trust or what have you. Somebody without any family actually might be a better candidate for a full estate plan with a trust, because it's more likely that they're going to have to name where they want their stuff to go. They don't have anybody who just falls on a lineage and it just easily goes to them, and they're writing them in as beneficiaries. They might have charities they want to give it to. It might be multiple. Not that you can't make a charity a beneficiary on your IRA or whatever. You certainly could. But they might have multiple, and they might have a dog, and they might want to leave that dog to somebody. That has to be written into a trust.
Mhm.
So believe it or not, I have clients who don't have kids, and it was actually a more complicated estate plan we did than if they had kids, and and if they own things. So that instance seems basic and whatnot, but believe it or not, it's actually not as basic as somebody who just doesn't own a house, maybe doesn't even own a car, leases it, right? And just has some type of savings, through a qualified account that has beneficiaries, and they have beneficiaries written in on their maybe checking and savings accounts and stuff like that. So it's all there.
Yeah.
Is that it, or anything else?
Okay, there's one more actually. Did you say that a trust is more expensive than a will?
Yes, a trust is more expensive. There's definitely more involved with it. A will's definitely cheaper to do. Just depends on like your situation and whether it warrants it. I can tell you this, one of the biggest reasons why people end up using trust is because of their homes. Because their home's usually the biggest value that they have in most cases. And if it's titled to you, there's nowhere to designate a beneficiary for. So most of the time, you have an estate, you put the house in the name of the trust, and now you can name beneficiaries for it in the trust. That's the biggest reason most people would need a trust. If you don't own a home, or even other valuables, and you don't want it to go to probate, you want your heirs to not be burdened with that, right? So in that case, I would, from my experience in the questionnaires that we used, that the estate planning, online estate planning service that I use, they use a questionnaire to determine who's going to use a trust, who they recommend uses a trust or not. And in those instances, if there's if there's ownership for things of value that aren't, like an account that can have beneficiaries written on it, like things that are items of value they can't easily have beneficiaries put on it. Most like, and a house being the number one, most likely a trust will be recommended. So usually you end up spending a little more, but it covers all those things that you wouldn't be able to cover. Okay.
Looks like that's it.
All right. Awesome. Well, folks, I hope that you found great value in this information today. I want to thank you for taking this time to learn more about creating your estate plan. While making plans for your estate, for your assets and your wealth after death isn't anyone's definition of a good time, the alternative is far worse. Remember, you can save your loved ones from a logical and emotional nightmare, logistical and emotional nightmare by putting your wishes in writing through a properly written estate plan. With that said, if there's anyone attending this workshop that is interested in creating a comprehensive estate plan and would like to learn more about how to do that, I would like to extend out to all of you a no obligation complimentary estate planning consultation to see if we can help you get that done. Rachel will be pasting a 60-minute meeting link in the comment box now. Have you done that already, Rachel?
Doing it now.
So you can go to her calendar and book a time that is convenient for you to do so. Also, if you have any questions either in regard to this topic or in general about any other financial matters in your life, we'd be more than happy to discuss them with you as well in a complimentary 15-minute Q&A phone conference to discuss any questions you may have before doing so. Rachel will also be pasting a link for the 15-minute Q&A phone call that you can book. You can also find both these links on our website at plcfs.com. You just click on the book now or schedule a meeting tabs on our navigation or at the top right side of all the pages on our site. Or you can also call us at 215-804-9708. And we'd be more than happy to discuss whatever's on your mind with you right there and then. Also, folks, please mark on your calendar Tuesday, May 30th, 2023 at 7 p.m. for our next webinar. We do them on the last Tuesday of every month. So for myself, Brian Dougherty, and my wonderful, beautiful partner in business and life, Rachel Dougherty of PLC Financial Solutions, located in Fort Washington, in the Fort Washington area. Have a great end of your month and a great May as well. And we will see you next month. See you, folks.
Night, everybody.